Welcome. My name is Mike Coy. We're going to work on remedies through the course of the semester. I see remedies really in major part as an extension of civil procedure and conflict resolution. A lot of students take it in their third semester. A lot of students take it virtually just before they leave. What remedies does is it ties together the various areas of the law that you should start to think about what lawyers do in practice. So it takes torts, it takes contracts, it takes a lot of modern statutory remedies, like one of the articles you just received is on the Americans with Disability Act. The other article you received is the one that's titled Lawyer as Peacemaker, which I'm told is not, somehow was not on the disc or whatever, whether it's on the disc or not, you now have a hard copy of it as well. And so what I like to do and focus on in this course is to try and look at issues that you are likely going to have in practice when a client comes into your office, and hopefully have a robust discussion about some of those issues, both from the standpoint of the legal issues involved as well as the practical issues that you're going to encounter when you look at some of these problems. And also the ethical issues as you approach trying to solve some of these, what are likely to be pretty contentious issues. So I hope when you read the cases, you think about them from a variety of angles, because many of the cases have a lot of different issues in them. It's not just about how the case got to a certain point and how you hopefully will be able to resolve it, but it's about all the other issues involved with how, from a practical standpoint, how do we get the client what they want, or maybe the idea is we have to give the client advice that they may not want to hear. And I think from a lawyer's perspective, that's really one of the hardest jobs we do. And it's something that, since almost all of you are closer to the end of the law school experience than the beginning at this point, that you have to start to think about as you leave here is, how do I manage clients' expectations? How do I, at times, deliver to them news they don't want to hear, but that they've got to hear? Because if you try to practice law and please everyone, that's not likely to be very effective for you in the long run. So what I've done in assembling the cases is try to look at things both from a traditional standpoint of what lawyers do with respect to sort of some classic torts issues, contracts issues, but also a lot of relatively recent issues that lawyers deal with and try to find remedies for their clients' problems. This class, not for you guys, but this class has an online component as well for those students that are taking it online. If occasionally you miss a class and you want to listen to it, it's up on the website at MS Law, the online classes and remedies, and you're welcome to do that. But since you've signed up for class, you're all expected to be here and hopefully participate because you're interested in the topics under consideration and debate one another with your thoughts on some of these issues. I want to run the list just so that I can see if how accurate my class list is, and then she needs to add people to it. So I'm going to do that, and then I'm going to talk to you a little more about what we're going to do through the course of the semester. Mohammed Abad?
Here, right.
Right. Celine? Elizabeth? Danielle Banks?
Here.
Victoria Black?
Over here.
Michael Brown? Andrea? Leah? Melanie? Fiona? Laura Gibson? Fred? James Judy?
Here.
Alina? Scott? Stephanie Mello? Chidera Michaels? Amber? Catherine Oko? Catherine? Geneva? Harriet? Mesa? Caitlin?
Here.
Britton? Who did I miss?
I just sent
Okay, oh, you guys, so you signed up today, so she'll put you on the list. let me tell you how the class works so that you have an understanding. We meet every Tuesday and Thursday. The sections are broken down for the most part that I try and do a topic a week. Sometimes we've got to do more than one. And sometimes you'll have additional assignments to do, like draft a complaint or listen to the DVD, give you an answer to 103 questions on Pro. And what I try to do is time some of those things for when I'm not going to be able to be in class. One of those times is next Thursday, where I have to be in New York with the trial team. So there won't be class next Thursday, but we'll have something for you to be able to work on as well. So next week, when it says section 2, we've got to do those cases on Tuesday. On Thursday, then, we're going to have someone put on that PowerPoint presentation. Some of you have seen more than a few times probably already, and just fill out the 103 questions. Because what I want to try and do, to try to make sure that we all have relatively the same base of understanding relatively early on, so that if I talk about SPV, we have some general understanding that I'm just not speaking in some type of code with about 3 of us. So I think the PowerPoint helps us to get closer to the same foundation, so that as we go through some of these cases and really start to look at them a little more in depth from the standpoint of procedure, that we can do that. As we move forward in the semester, if you have the syllabus, you'll see that there's a midterm examination. What I have done in the past, and you can decide, you don't need to decide this today, online students, those that are taking it online, there are questions posted each week for those students, and they then submit them within a week generally to me by email, their responses to those questions. Questions are based on the readings for the week, our class discussions, and some of the issues that are raised obviously in those cases. That's what they will do until we get to the end of the semester, when they will take the final exam along with you guys. What I've done in past years, and I don't have a preference for it, and I don't know, you might want to check with students who have done it before. I've given the in-class students the same option. If you would prefer, as your midterm evaluation, to be able to go take all the questions posted and to review the material and write out answers to those questions, instead of coming to class and taking the exam in class, then that's fine with me as well. You don't have to decide today, you need to think about it, and we have about 6 or 7 weeks till we get to that point at any rate. But I'm flexible on it, you decide what you would rather do. Some people prefer to just sit down and take the exam, other people prefer to look at all the questions, sort of use it as a good point of review as we get further into it. But that's an option you have, but we can talk about it as we get closer to that. As we go further with the rest of the semester, you'll see we work on our cases and have our discussions, and then just like every other class, you have an examination at the end. That'll be a 3-hour examination where you will answer at least 1 essay, maybe 2, and a series of short answer questions. What I would recommend to all of you is you look at the old exams, try to see what the format looks like, and try to go over some of those problems, because I think a good way of getting ready for this final examination especially is to look at prior exams and get comfortable with the issues tested there, because for the most part, whatever class it is, the law changes relatively slowly. Technology changes, other issues change so that they become more testable or tested, but the law doesn't move quickly in response to some of these. What we do more often than not is apply old law to new technologies and new problems, and that's what a lawyer does forever. I already messed up once. So for remedies, what you should do is start to think about what the law is, think about the problems as we go through them, and then get ready to take, if you choose, the midterm and the final examination. You have a few problems at the back of the essay, if you look at it, that I'd like you to email me with. Some of you have already sent that in, and a little bit about trying to blend Rule 11 into your lawyering. And then I've got some questions that are specifically geared to issues that more commonly come up with respect to what we would call, what has been called in the past, equitable remedies, but now is called remedies in general. is it good lawyering to fail to attempt to give any notice on a TRO? To what extent are you going to use the rules for tactical advantage? And I'd like you to start to think about that. Under what circumstances is it appropriate to use an injunction to force a speedier resolution of the case? Some of you may know, all of you will need to know, that injunctions are heard very early on in the case and can force the parties to assess their merits of their case, both pro and con, very early on, because that case may move at a pace much faster than some parties want to proceed. Would you ever, or under what circumstances would you inform your client to violate a court order? Obviously, if you don't know, you will, but that carries with it the sanction of contempt. So obviously, if you're going to do so, you better know what the ramifications are. And then how do the lawyer balance the need to make money with the client's right to a speedy resolution? And I think from the standpoint of transitioning from law student to law practitioner, this is something that we have to start to really think about in a concrete manner. It's easy for me to say as a law school professor, say, well, you know, you should turn away cases where they're not likely to succeed and where you're going to run up a big bill without necessarily getting the benefit that the client wants. But by the time you get out of here, you're going to have some bills paid, bills owed, money bills to be paid. And the fact is that it's easier with some distance and some money in your pocket to say no to what are more marginal cases. But at the outset, you're going to have more of a challenge. Someone puts a big pile of money on the table and says, I really need you to do this. Do you think we can be successful? And the fact is, you've got to balance the needs of the client with being able to convey advice that isn't in your best interest. But it's not supposed to be about your best interest at times. So I want you to think about that issue, because a lot of these cases have issues of ethical proportions to them that I'd like you to think about where your own boundaries are as to what you will and won't do, because it's easier to find them here than when you're actually practicing. So I think if you look at the cases, I'm sure you're going to have some thoughts on them anyway. But there's more than a few where I think we'll probably disagree as to what is the right thing, even if, for the most part, the law might authorize it, or clearly there's no ethical sanctions coming, but some of the things don't quite appear appropriate with some distance to them. Do you guys have my chart, this chart? Is that part of your package? You have this? You do? You want to pull it out for a minute, or pull it out for a few minutes? Do you guys have it or not? We don't all have it?
No.
I'm going to run downstairs and just grab them. They're right outside my office.
Download everything in here, or
Yeah.
you use the CD?
Well, I make sure it's all here.
Yeah.
You know, I was looking at it earlier.
So you can,
He wants us to answer all this. So that way, like that. Yeah, so could you start doing it
Oh, yeah.
That's your second.
He doesn't hang a lot.
Why did you say?
We're good.
One other thing I'd like you to do is bring a rule book with you, because each week, there's usually at least one rule I'd like to focus on a little bit, so that we take a closer look at it. I use this little one from West. I don't know whether you have one like this, or I can try to see if Sugar can get us some more. But just something to throw with your material, so that when we do focus on them, we can look at the language a little more closely than we might otherwise. One like this. Want me to see if Sugar can get us some of these if you haven't already have one of these?
Sure. I need one.
Does it hurt? Okay. I'll try and see what she's got downstairs for us. Take a look at the chart. What I tried to do is visually represent the flow of a case from the time it's filed to the time it goes to judgment. This is a different type of representation than the 103 questions, but it gets to the same place before we're done. And what it's supposed to try and have you start to think about is really how a civil case begins, how it would be discovered, and then ultimately what the variations are, either going to trial or resolutions procedurally without trial, motions to dismiss, summary judgment, things along those lines. And so I need you to start to think about, well, what goes into a complaint. When a client comes into our office, they're bringing us a problem that doesn't say torts, contracts, or things like that on their forehead. It says, they say, I want my job back, I want to stop my neighbor from doing this or that, I need a contract drafted because my cousin's going to have my baby, and we want to figure out all the issues that are attendant with those types of things. And so litigation, and that's all this represents, is one of the methods that historically dominated the method of dispute resolution for lawyers, but it shouldn't necessarily be yours. You have to be aware of the litigation alternative and how it works, because I think the best way to settle something outside of court is to have the ability to be able to settle it in court. And so you need to start to think about solving those clients' problems from the time they come in. And what partly that means, well, understanding how the litigation process works. So I'm not going to hit on everything in here, but just quickly, as you think about it, off in that top left-hand corner, you know when we file suit, court has to have subject matter jurisdiction, personal jurisdiction, and venue, right? Subject matter jurisdiction is the power the court has to hear the case. Personal jurisdiction is the power to bind the defendant to the judgment. And venue is a much more mechanical application of where D is, or where a substantial part of the events giving rise to the cause of action occur. All three have to exist before you can file suit. And that suit, as you're going to find out if you don't already know, it is started by way of a complaint that can have multiple counts within it. Right? If you look at some of these cases as you go through the course of the semester, oftentimes they involve both state law and federal law within the same complaint. There's a count for a variety of things. Some of the complaints we are going to look at might have 6, 7, 8 counts. Torts, contracts, 93A, a consumer fraud violation. They might have, within that complaint, both someone seeking damages for breach of an employment contract, as well as discrimination under the Americans with Disability Act, or sexual harassment, or a failure to accommodate and the like. All of those go into our complaints, because when the client comes in, they've got a problem, but the problem oftentimes in the real world isn't narrowed down to, oh, this is a straight tort problem, right? This is a breach of contract problem. The fact is they've got a problem, and you are supposed to figure out a solution. And all of that is started by way of a complaint. In the complaint, it's not always simply about money. Historically, this course would have been called equitable remedies, right? Remedies that really may tangentially involve damages, but much more likely mean orders of the court to do or not do certain things, injunctions, declaratory judgments, specific performance, right? Replevants, actions that at law would not have, at common law, would not have necessitated a jury, and would have been done under sort of the guise of what's the fair or the right thing to do. From a modern standpoint, we oftentimes will have within a complaint requests for both what we would call equitable relief, injunctive relief, maybe declaratory judgment in there, as well as claims for money damages under various statutory means of relief or common law claims. And so all of that thinking has to be, you have to do all that before you end up filing your complaint and understanding, well, what is we want to get, what are my best arguments for getting there, and then obviously the procedural issues about, well, where we file, where we think we gain the most tactical advantage. All of that is done before you ever even file your suit. Hopefully you spent some time thinking about trying to resolve it with the other side as well, because we know litigation is costly, it's time consuming, and it may take years before the client gets what they're like, what they're seeking. The problem with that is that the defendant's best friend almost always is to stall the matter, delay the ultimate resolution in hopes that the plaintiff will go away. So we can sit here and we will talk about a cost-effective dispute resolution, arbitration, mediation, conciliation, having you use your negotiating skills to try and resolve matters sooner rather than later. But again, as a practical matter, we're going to look at some of the impediments to that as well. You know, how do I get them to the table? How do I get someone to think resolution at the outset when I may not have enough push to be able to get them to the table? The fact is, I'm going to ignore you more often than not because maybe you'll just go away. Well, that means oftentimes then that we have to show that we're not going to go away and we need to file suit. But then even suit gives us numerous opportunities to start to think about resolving that matter. There's a bunch of issues on the right-hand side of the chart that says you need to think about when you're filing suit, such as who are the parties, who should be there, are there means of joining multiple parties in this action, a class action? Do I need requests for injunctive relief? We'll talk about what injunctions are and what they do, you know that. Whatever that is, ultimately in your complaint, needs to be served on the defendant. And then the defendant has various options from there if you look at the chart. If they don't answer, a default judgment will issue. If they do want to respond, they can either respond by way of a motion to dismiss under Rule 12, or they can file an answer. And if they choose to file an answer, obviously they can file any counterclaims under Rule 13 as well. From there, the flow of the case is if, in fact, if you look at the chart, if the motion to dismiss is filed, it tolls the time to file an answer. But once the motion to dismiss is resolved, assuming the defendant is not granted the motion to dismiss, and the answer is filed, at that point, we have a general understanding of what the issues in the case are, and at this point, we can engage in discovery. In federal court, before you can engage in discovery that's listed here, there must be voluntary disclosure of information to the other side. That's going to be a paper that describes who the parties are, who the needed parties are if they're not already there, who the witnesses to the case may be, where essential material might be, documents and the like, and what the parties value the case at. The idea in federal court is that if the parties make this voluntary disclosure, perhaps they don't have to engage in this paper war that lawyers do in civil litigation, that is far too time-consuming and expensive, but frankly, it is where lawyers make a lot of money in civil cases. If you're working on an hourly, the fact is all of this paperwork can generate vast amounts of money. So there's a disincentive for a lot of lawyers to assess their case early on as a practical, at least in their own interest, as a practical matter to trying to resolve the suit. Still doesn't mean it's not in the client's best interest. And so that's where you guys have to start to think about, well, how do I cost effectively move the client's case forward, where at the same point I may be opposed by someone who's intending to drag it out, take every last dime out of the case, and then settle on the eve of trial. You know, historically, that's still the approach, especially with big corporations, big business. They expect that you will walk away before someone will hold out to the end, because it gets very time-consuming and expensive and emotionally draining. And so what we have to be careful about is using the process properly so that to our client's advantage, and at the same point, to some extent, be careful about wasting time, but an awful lot of time, unfortunately, can be wasted in the civil discovery process. The problem is you don't always know whether it's wasted time till far down the road. And so you push and you fight and you put in the extra effort, and hopefully you are doing that with some eye towards how much this is all costing the client. Because you can't have cases, obviously, that cost far more than the client may ever see in return. And that's a conversation you should have had early on. And I think especially for lawyers just coming into the practice, that's a hard assessment to make without some more seasoning or someone who you can bounce ideas on. And so I think that's important to start to think about that. I mean, how do you realistically assess a case early on to say, well, is it going to be worth it? How much is this likely to cost? What's the return? And having a real dialogue with your client about that. The problem, at least in part, is, well, you don't necessarily know. Well, hopefully we're going to learn a little more about that here and start to think about that, because, you know, I used to work with a lawyer. He would promise them the moon, we'll say. And he would be able to bring in a lot of money because they were sure that they were going to get what he promised. But then, oftentimes halfway through, maybe a little further down the road, they're out a lot of money and the prospects aren't looking nearly as bright as they were painted. And now we've got a hornet's nest of a piece of litigation that's not going to go away. The client is not happy, and the client is not likely to ever see a real return on the money that they've invested in this litigation. That's likely to result in a complaint to the Board of Bar Overseers against you. That can't possibly be worth it after all the time you spent in law school. So that whole notion of, you know, making a realistic assessment at the outset, and especially, I think, from the standpoint of the new lawyer, turning away the cases that you need to turn away, right? Because I think there's a natural tendency you want to help. Hopefully that's why you came to law school. And so you never want to turn away anything, because maybe you can help. But if you're not going to pay attention to it, because you've got other things to do, or the case is a mess, then you shouldn't have taken it, because you're not doing yourself or the client a service under those circumstances. And making that assessment early on, before you ever get stuck with the case, is important. Making assessment early on before you've spent $5,000 or $10,000 of the client's money, and now have to go back and say, this really isn't worth it.
When you have a client that comes into your office for any particular problem, and you give them advice and they're asking what the outcome should be, do you just refrain from answering that? I mean, in other words, how do you respond to them by either saying, I can't guarantee anything?
That's easy, right? Of course you can't guarantee.
Right.
What were you going to say?
But then that was, but wouldn't that
Are we likely to win, Ray?
I'm sorry?
Are we likely to win?
Well, if I told them that I can't guarantee anything, then doesn't that sort of
That's
look bad
different.
on me?
Well, you can't possibly guarantee anything, can you?
No, no, I'm not saying that.
No,
I'm
no,
not-
no, right, let's just let's talk about it realistically for a minute. I mean, you're not God, you're not sitting as 12 people in the jury, right? So you can't possibly guarantee anything. Let's take that off the table.
No, that I understand.
No, no, but we all agree to that.
Yeah.
Okay, so tell me what you can do.
So,
Because you want to stick your hand in my pocket and take a big wad of dough out of there, right?
Sure.
Okay.
So
So
if
tell me
I
what
could-
I get for that.
so if I told the client, I said, listen, anything can happen,
Yeah.
but this is what is likely to happen, is that okay?
What do you think? First of all, let me take the other part. Okay, you can't guarantee anything, and anything can happen. Agreed? Right? You try the best case in the world. Jury doesn't like you, doesn't like your case, doesn't like your client. They say, see ya. Right? So you can't control everything. So you can't guarantee anything, and anything can happen. Those are the extremes here, right? Okay. So now what can you say? Go ahead.
Tell them the law, like what you know
Yeah.
the law to be, and this is, you know, how it's been applied, and apply the facts. Say this is how it's been interpreted.
So how do you know what the law is in that first conversation?
Well, you would have to.
No, right? Sure, because again, listen, I'll take an easy example. It's not remedies, but take an easy, you have a client call you with the driving under the influence case, right? One of your friends, sooner or later, will call you because you're the lawyer now. And they're going to say, I was arrested for driving under the influence, I'd like to come talk to you. Okay? Now you, listen, you don't know squat about DUI law, right? Hopefully. But what you did learn in law school is the ability to look it up, right? To look up the statute, figure out what it is, and so you're going to look at the statute, figure out what the elements are, and now you know a little bit about it, and now what? So, okay, I looked at driving, public way, intoxication, ability to drive safely impaired. It's really pretty straightforward statute. So what do you think? Is it worth it? Go ahead.
So I think you would apply the law to those facts and come up with a result that in the past, what has happened with those facts is that you're in trouble, basically.
Yes, you are likely to be in trouble. Do you think we can defend it? I mean, what am I, and now let's the dialogue, right? What are my options? And so you need to know that. And again, it's a little more difficult early on because you haven't been in court, you don't have the experience, you don't know necessarily what they are, but you've got to look, or you've got to talk to someone more seasoned and say, listen, I'm in Lawrence. When I first was practicing, it was, you didn't want to go to Quincy, because Quincy, for DUI at least initially, because Quincy was just terrible. It was the outlier of all the other courts, and if so, but depending on the court, depending on the judge, depending on this, which a lot of that you don't have yet. So that's the question is, well, how are you going to acquire that ability? I mean, are you going to have someone that you could talk to and say, listen, I got a DUI in Quincy, right? What are the minimum to the max? What are we looking at? What do you think we can do? And again, DUI is not as good an example as it one time was because it actually may be better for new lawyers simply because it's pretty straightforward what the variations can be, and they're not that significant anymore. So you could find all of that out. But now you still want, suppose you got a DUI, it's, the arrest was at 6 o'clock at night. You got a breathalyzer reading of a 5. 6? Give him a 6? I'll give you a 6. I'll give you a 6. But of course, most of you don't even know what that means with respect, because you haven't looked at the statute, right? But there's no presumption at a 6. We'll say you got a 6. Less than 5, your presumption not. Over 8 or more, presumption that you were. So you got what would be a potentially triable case. So, how much? That's something. How much? So you got to think about that, and how much you think you get from me depends on the advice you're going to give me as to whether you think you can win this. We have a triable case. You got a early evening arrest. 2 a.m. or later. They're never good, right? No, they're not. They're not. Seriously, know, you gotta try the case with, jury has common sense too. They know what's going on at 2 and 3 in the morning.
Next word on the breathalyzer.
Well, and that's gonna cost us some money potentially. But a 6 is a reading that you could live with. A 6 is a reading you could live with. So tell me, what do you think? What are you gonna tell me? You got a shot? You can't, we already said, you can't guarantee me anything, and
You have
anything
a
can
record
happen.
of it?
Huh?
This is the first offense?
Yes, that's the first offense. That's the good one. Well, listen, by the way, that raises a problem, and you need to know that information as well. But in Massachusetts now, first offense is forever, right? So these become important cases because that means for the rest of your life, that one's the first one. So the next one becomes number 2, and the penalties for 2 become significantly more serious than 1, and 3 becomes significantly more again. So here's the point, and just use this as an illustration. You have to balance overselling, because the guy I talked about, he constantly oversold. And it was a mistake, because sooner or later that you can't, if you can't deliver what you've said, then that's where the complaints come, that's where the problems come, and you ultimately won't be practicing law very long. So how do you know, they want to hear you can win. And I always kid around like with this conversation when you say, well, I think we can. I think based on what I know, we've got a good case and things work out well, I think we can help, right? Okay, that's still, you haven't said much, we can help. But, so, listen, if you want $5,000 from me, you think I can win, you think we can win this? And that's what they're gonna ask. What do you think?
If it's a 6, I mean, you could get them, you can promise, well, you can't promise anything, but you can at least say that they'll get some sort of a lesser fine or just do community
Is that true?
service. Well,
You're just making it up now, Lee?
possibly.
Well, that's not a good way to start your first day of practicing law either.
But they could get, you know, a lesser charge, for example, depending on the circumstances.
Not a lesser charge, probably doesn't make a difference whether it's a .06 or a .26. The charge is gonna be the same. It's still DUI. Question is, can they prove it? And that's what you have to, and of course you don't know. You know based on experience you've got a case. It's certainly better than, as I said, you got a .26, good breathalyzer, you know, bad field sobriety test, you're in trouble. But that's the other thing, we don't have all the facts, but at the end of the day, they still want you to make an assessment that, you know, if things turn out, and that's the other part, right? If things turn out the way you're saying, then it sounds like you have a triable case.
Or I think what she was saying is much more likely to be able to negotiate a reckless operation.
In New Hampshire, you have a better chance, not in Mass, that whole negotiating down is virtually removed in Mass under the
Really?
Melanie
So you
standard.
can't plea bargain?
He would, yeah, once the ability to file that or dismiss, the paperwork that's involved with the judge having to agree and put it all in writing, they're virtually undealable in Mass now.
Really?
Yes, yes.
Bad for lawyers, bad for.
Well, that's right. But that's right. It's good. It is good. The concern was that there was so much variation that the statute has removed a lot of the discretion that previously existed, and they do become, as you said, good for lawyers. They're big fee cases now.
Yeah.
But here's the bottom line. We'll look at other cases with it, because we've got a lot of these issues where there's some questions in the case about whether the attorney did their client a service or disservice at the end of the day. And what I need you to start to think about is recognizing it at the outset. I mean, I took cases early on, not unethical cases, but just crappy cases that I wouldn't touch now, simply because you get the benefit of experience, also a little more money in my pocket than early on too, right? I mean, firm says this is your client, this is your client. You don't have a lot of say necessarily, either quit or represent the client as you can. Go ahead.
Are you saying, so you got a guy, it's a 1 a.m. .24 DUI. Are you gonna not take the case, or are you just gonna explain to him that the likelihood of success?
Oh, I'm gonna take it.
Yeah.
If you're looking to pay me to do it, I'm gonna do it. And I'm just saying,
I mean, you still need somebody to represent them.
Still need representation, I could still do a better job than most, but the likelihood of a not guilty on a 2 a.m. post-Bruins game.
Right, you're just not gonna tell them.
You don't wanna
You know.
Probably win
Did they
that.
win?
I had a guy on Storm Drive, he was pulled over, he couldn't get past C. And then, on the outlet, and he said, you know,
Yeah.
I don't know why I can't say it, I knew it when I was little. Police officer wrote it right down in the court, of course. My wife had one in Somerville. Again, he was pulled in somewhere after 2 a.m. and they have a video camera in the cell, and he's put in the cell waiting for the breathalyzer. They're supposed to observe him, and he's shown on the video taking the toilet water from the toilet in the cell, in a prison cell, shoving it down his throat in order to try and dilute what he thought would be the sample. And the video obviously is far more incriminating than any breathalyzer would, because if you've ever been in the, you don't even want to do what you're supposed to do in that facility, much less drink the water that comes from it. But that's what he did, and they've now got a video that certainly says drunk to virtually anyone who sees it. And so, you know, again, that's the type of thing is that if, in some of these cases, if you can get your access to the material quickly enough, you can make a relatively early assessment. And that's the thing, but some of that comes from experience. And same thing with civil cases. Right, I mean, over time, you become a little more skilled, but again, we've got to try and figure out how you can do that early and be comfortable with it. Because that's the other question that you then have to deal with, right? Okay, I'll give you the $5 grand on the DUI, probably. Well, how do you deal with the question when they say, well, have you done a lot of these before? Right? I mean, because,
You have to be honest.
so what? No, but you're the first and I'm going to do it. Damn good job. I'm really excited on this one. No, I agree with you. Honesty is where we start, but that's a tough question to field and expect that someone's willing to part with thousands of dollars when you say, nope.
Well, just say
Never even been to court. Obviously, you're not going to volunteer.
well, just say you're undefeated.
That's, yeah. Ray, why do I worry about you already? But there are ways you have to start to think about. Listen, what part of the thing, and this I always felt this early on, you have to then end up having to master the law far better before the client ever sets foot in the door, right? Because you don't have that experience. You haven't been to court. You better know the right questions to ask. You better, when I sit there across from the table and you're going to try and take thousands of dollars from me, you better give me a comfort level in what you ask, the manner in which you ask it, frankly, the manner in which you appear. All of that, I better get a comfort level, because if you're asking me to write a check out with a whole bunch of zeros on it, and that's what you're going to do sooner or later, I better think that you're highly competent to be able to successfully carry out what I need carried out. And I think that comes from the confidence in which you come into the meeting with. The fact that I would oftentimes do an hour's worth of research before the client ever came in, because early on you don't know what questions to ask, right? You don't want to sit there and be confused. So sometimes it's not just you do your research. I'll tell you what the law is. I'll tell you what the options are. I'll tell you what we're looking at. And same type of thing with the civil case. Some of it is I need to know what information to get to look at, right? DUI, frankly, if I get access to the police report quickly, and I can hear your story, I can tell you relatively quickly whether we have what I think is a triable case or not. And same, type of things with other criminal cases, right? I can take a quick look and tell you whether we've got suppression issues here or not. Still, I can have, listen, Miranda, oh, I know, guys, that's really important. It is, okay. But, so you weren't Mirandized. They didn't talk to you at all, okay? It's not a violation. They found you with a trunkload of dope. They didn't need to talk to you, okay? So in some police departments, Miranda really, if they're not going to interrogate, okay, you weren't Mirandized. That in the real world, we don't have a confession. What are we looking at? There's no violation. but I know in law school, well, we want to see all the I's dotted and the T's crossed, and that's nice, but at some point, the rubber hits the road, and at some point also your client lies, right? You need to recognize as well that he did say you could search through the car, even though he's got a bag of dope right in the back seat. So we'll talk about those types of things, trying to make your assessment of the case. But in civil cases, a lot of how we start to make that real assessment is through the course of discovery. And we're going to look a little more closely at that, but if you look at the chart, it talks about the different methods of discovery, most of which, as you know, are limited to parties only. There are means of obtaining discovery from non-parties, from witnesses, and that's generally going to be a deposition, which is the most common form of discovery, coupled with a subpoena or information that they can bring to that deposition.
Can I ask this?
Sure, of course.
So, is it possible to do some form of discovery or investigation in civil cases prior to filing a complaint?
Not really. That's what I talk about. That's why I talk about Rule 11 is really what you're required for filing suit to make an investigation into the case that Rule 11 requires you in the federal courts. State courts have Rule 11s too, but they're not as stringent with respect to enforcement of those. I think it's simply good lawyering to do that type of investigation before you ever agree to put your name on a complaint or, in some cases, even represent the client. The fact is you need as much documentation as possible. You need to talk to the witnesses. Some cases you might need to see the witnesses face to face. There really isn't this process of discovery that we would like to have, a good lawyer would like to have at the outset, and so we rely a lot on what the client tells us. But you even can't do that. That's why you need to see what paperwork there is. What's the documentation? I have a contract with my employer. Well, I need to see it. All my evaluations before I asked for an accommodation for a disability were great. I need to see them, right? I mean, the idea would be, the idea hopefully that you guys will come away with is, get that before you ever file suit. Get that before you ever get so deep into the case that you may not be able to do it. I don't want to sound overly cynical as someone who's been a lawyer for a while, but clients don't always tell us the truth. They tell us the truth as they see it, right? As they saw what took place. To them, that's the truth. The fact is that that's not always entirely accurate, simply because we see things through our own experience. We tell you what we think took place, even though at times we would tell you that is what took place. And so, and even if they're 110% certain that those are the facts, what evidence do they have that supports it, right? Because that becomes crucial as well. Everyone who files a suit, every defendant ends up with a target on their back. And so you can have, I had this Eagle Scout one time I represented. And it took me halfway through the case to figure out, I've got the Eagle Scout, and the other guy's the bad guy here. But even everything there wasn't 110% the way it was portrayed initially, because that's just the way it is. And even with the Eagle Scout, they were painting him as the absolute bad guy, the devil himself. That's the nature of it. And so you've got to have, even if you do have what you're certain of the facts because you believe your client entirely, who else supports that version of the events? What other evidence supports it? And the best place to get it is before you end up in the middle of suit or somewhere else. Because if they can't provide that, if they can't provide you witnesses to what they say took place, if they can't provide the documentation, if there isn't anything other than your client's word, that's a tough case. Because no defendant is ever going to just simply agree so that you can either make them pay an extraordinarily large judgment or discredit them with their employer so that the person's rehired by way of an injunction. You know, that's the problem, is where is the support? And I think the best place to do that, to gather that information is part of your Rule 11 investigation, which is required prior to filing suit. Because this discovery is much more detailed. Now, with that said, you can bring this, a case, simply as means of obtaining discovery in aid of future litigation. So sometimes we will file a case simply to take a deposition, for instance, in a different state, to preserve that evidence in order to file suit somewhere else.
Do you know that in the complaint, so you can do
Yeah,
that?
yeah, but it's rare that you would do that, because you still should have enough support elsewhere. And if you don't have it, then this is one of those things that I'm saying now, well, think before you go and do it. Because, right, the less support there is for it, it's not just the plaintiff and defendant who have targets on their back, you do too. You know, we have to practice law to some extent defensively. Because, like it or not, that you as the new lawyer also have the target on your back, and there are an awful lot of older lawyers who are bullies and are going to try and push you around and are going to try and tell you don't know what you're doing, and they're going to try and win through any means possible. Now, we can say that that's not right, and that's mean, and that's not playing fair, and it's none of that. It's all, you're absolutely right. But are there people that are going to do it? You bet. So, and especially early on, when you don't have necessarily the confidence that you will have later on, you know, someone says, well, that's simply unethical to suggest this or that. Hopefully, you worry about that, because hopefully you want to practice ethically. But the fact is, sometimes they're just going to do it as a means of intimidating. Lawyers will actually look you up to see when you graduate. You know, I'd like to know, am I working with an experienced attorney, or is this a rookie? And we all do. You know, you want to know who your adversary is. That's sort of pretty common. And so you want to be careful that people don't use that then to try and push you around because you don't know what you're talking about. That's why it's important to, before we file suit, get into all of this to know what we're talking about. We'll talk about that some more as well. You got 3 testing motions, as you know, I call them. A motion to dismiss tests the complaint at the outset. A motion for summary judgment tests the pleadings taken as a whole prior to trial to see if there are material facts in dispute that rise to a triable level. And the third of our 3 testing motions is a motion under Rule 50, motion for a judgment as a matter of law, which tests the evidence introduced at trial to see if a reasonable jury, on the basis of that evidence, could find for the other side. So it's a motion to dismiss, motion for summary judgment under Rule 56, and a motion for a judgment as a matter of law under Rule 50, that all test different things, and they come at different times in the process. But those are the 3 major motions in a civil case. Civil case, the standard of proof, unlike a criminal case, the civil standard of proof is preponderance of the evidence, right? Tip the scales ever so slightly in your favor to show more likely than not what you're saying is true. Some civil suits have to be proven to a clear and convincing evidentiary standard, but there are very, very few where clear and convincing evidence is required. Malice in a tort case, in a defamation case, is needs to be proven to a clear and convincing evidentiary standard. Fraud, as a general matter, needs to be proven to the higher standard of proof. Most civil things, it's more likely than not. Federal court, jury must be unanimous unless the parties agree to something less than a unanimous verdict. But in Massachusetts, all you need to do is convince 5/6 of those jurors to agree with you. You do not need a unanimous jury in Massachusetts to win a civil suit. Jury interrogatories under Rule 49, that's simply breaking the jury's burden down into digestible pieces, asking them questions so those questions can lead them to provide something other than what a general verdict form is. General verdict form is simply when the jury comes back and says, we find for the plaintiff an award $1 million or $2 million or whatever it is. Jury interrogatories, special verdict forms help to break that jury's verdict down so that gives them a roadmap as to how they need to get to their ultimate decision. I already talked about Rule 50, and then as the case winds down here, it becomes a judgment for either the plaintiff or a dismissal of the case. And in a lot of equitable type measures, it comes down to an award of a permanent injunction, which would unless reversed on appeal, would order the party, usually the defendant, but an injunction can be sought by way of a counterclaim by a defendant against a plaintiff, would order that party to do things or to refrain from doing things if the five-part test is satisfied for injunctive relief. Also, other types of permanent judgments the court can issue. Declaratory judgment, where the court determines what the rights and obligations of the parties are and issues that judgment determining what the rights and obligations of the parties are. A specific performance, a contract remedy, or a remedy where unique goods are in place. Usually it's real estate, sometimes it's very unique goods. The court will order that the terms of the contract be performed. We're going to look at other types of both remedies that can be ultimately awarded as also as methods, means of obtaining different types of remedies. Still, the classic remedy that we're going to see in a lot of these cases, we're going to talk a lot more about it, are damages, right? Monetary relief. And there's a bunch of different sections here where I ask you to think a little harder, not just sort of about general items of damage, but where the rubber hits the road. How do you prove pain and suffering? How do you estimate what the damages are for wrongful birth of a child, right? One of the groups of cases we do is it possible to sue when that contraceptive method doesn't work and we have a healthy child born with that? Can we obtain damages as a result of that? And if so, how do you measure the damages under those circumstances? And so I want you to think about those. We have unique personal property or other pieces of property where we really have to start to think about, okay, I have a general idea about making that plaintiff whole. As a lawyer, how do we go about doing that? How do we provide that proof and the like so that the jury can agree that we should be entitled to relief? And then we'll talk a very little bit about post-judgment remedies. But again, in the real world, post-judgment remedies become important because we have a tendency to think, okay, we won our case, we've got a judgment. Well, in a lot of cases, that's not the end of it. Because if there's no insurance company to come in and simply write you that check for whatever it is for damages you've won, now we've got to figure out how we go about satisfying that judgment, collecting the money that's due us. And so there are various post-judgment remedies we'll look at, one of which, by the way, is you can do discovery post-judgment in order to try and figure out what assets the defendant has in order to satisfy that judgment. There are other attachments and other methods of attempting to satisfy that judgment that we'll talk about and start to think about as we go through the course of the semester. Questions? You've got a fair amount of reading if you look at it for Thursday now. The Lawyer Turns Peacemaker article you should have. There's a new piece on the ADA and a new case, because that's actually for next time, the ADA one, where you look at the McGinnis and Toyota case. But then I want you to look at Rule 65. I think all of you had and looked at Weinberger for the purposes of orientation, but I think for the purposes of equity and remedies, it's important to take a little closer look at it. And I think both the majority and the dissent there are really well done. And so we're going to spend a little time on that. Take a look at Clinton versus Navy, which is just a simple district court case for injunctive relief. And Norwalk Core is also a district court case for injunctive relief. If you were to look at the field of equitable remedies and how often they utilize, injunctions probably account for 80% of that field. So we spend some time looking at not just the five-part test, which is really sort of the beginner entry, but we look at the whole process of obtaining injunctive relief, what type of hearing you're entitled to receive as a result of that request, and how does the court balance both the person who's seeking injunctive relief and their need for immediate relief with the burden that will ultimately fall on the defendant. In the real world, that oftentimes comes in with respect to the issuance of the posting of the bond. So we're going to spend a little time looking at what that bond requirement is and how that works as well. So look at the cases all carefully. What I've tried to give you in the cases is the actual cases. So you will have the majority and the dissent. You don't have a lot of cases that are edited already. Your classic, case book that you've got, the editors have gone in and chopped it up and decided what pieces are important and what aren't for the purposes of torts or contracts or whatever it is. As a lawyer practicing, we don't have that same benefit. When we find a case, as you've done probably in research and writing, you've got to go through it, figure out what's important and what's not. And that process also becomes important for being a lawyer. And so all of these, you're going to self-edit. You're going to figure out why the case is there and why it's important. Most of the topics really are single topic sections and the like, so I don't think it'll be that difficult. But I do think it's important to start to look at these cases and really start to figure out how we use them as clients come to us with problems and are looking for you to assist them with resolving those problems. So, and think about the issues that are raised, both there and as you start to think about, well, this is how I want to practice law, this is what I want to do, this is how I intend to do it. Because there's a lot more than just knowing the law that does go into actually practicing law. Questions on any of this or the requirements over the course of the semester? We good? The online piece doesn't really affect you guys much at all, because unless you choose to take the midterm exam by way of questions, that's the only really thing that's different. For the online people, they're held to the same standard as you. Everyone's taking the same final exam when we get together in May. So by the time we're done, we've all done the same amount, same work. Questions? Okay, see you Thursday. And if you didn't get the ADA article, the chart, or the lawyer turns peacemaker, they're over here. That's gone now? Yeah, I've got a hard copy out of it.
Laura, first one, I don't know if they will get an order.
Weeks ago. What? Oh, no. You're Sabbath week?
Yeah.